Welcome to This Week in Family Law, the go-to podcast for busy Australian family lawyers looking to stay updated without the overwhelm. I'm Jenna Downey, a family lawyer and the Managing Director of Leap Family Law. My co-host today is Dina Palethorpe. How are you, Dina?
I'm very well, thanks. How are you?
I'm good, thank you. You've just come back from holidays, haven't you?
I have. I spent 2 weeks in sunny Queensland, although it wasn't sunny for the whole time, unfortunately.
And did you have a good time?
I did. I had a lovely time, but it was nice to come back to work and to come straight back into this.
And let's get straight into it. What's up, Dina?
Well, so this week, probably the most important thing that's come out of the news is we've had our first successful prosecution of a coercive control offence. And so that's pursuant to the amendments that came in 2024. So that's the Crimes Legislation Amendment Coercive Control Act of 2022. A really interesting case, which we might talk a bit about in a separate episode.
Yes, we will do a bonus episode on that. So if you're interested in tuning in, keep an eye out for that one. Our second update is based on an article from the Law Society Journal, which is called Self-Doubt to Confidence, and it's written by Natalie Cull, who I believe is a young lawyer. She talks about imposter syndrome, which I feel like is something we wanted to share because it resonates with a lot of people. I know I've certainly felt it, and you might have as well,
It's definitely resonated
Dina.
with me as well, yeah.
And she says that since uni, she had it, and she thought it would go away in practice once she officially belonged to the profession, but the feeling in fact got worse. And then she says that she felt anxiety in everyday tasks such as drafting letters, sending emails, and asking the partners to review all of her work before it was sent out to clients. And she also mentions court appearances as well and the anxiety that she felt there. She said that even when she received compliments about her work, that she found it hard to be grounded by that and to develop further confidence from that as well. And she mentions an important learning being that no one begins their legal career feeling completely ready. And it's something that I hope any junior lawyers listening, they do take that into account, that it's not necessarily you graduate from law school and you're immediately ready to practice. There's a lot of skills learned, including competence and confidence, which the author goes into in the article as well.
I think it's just a part of practice. The more you're in it, the more you realise there's so much to know, and almost how can I know all of this? And, you know, you'll meet people, you'll have interactions with counsel, senior counsel, and you'll think, wow, the breadth of their knowledge is so great. But you've just got to take a step back and realise, you know, I'm a junior lawyer. I'm not expected to know everything. Maybe, hopefully one day I will get to that point, but just to not be too hard on yourself.
Exactly. Yes. If there's any advice we can give at this point, it's exactly that.
So we have another update. This week on Thursday and Friday, we have the FLENA Disrupting Tradition course.
Excellent.
Yeah.
And our final update is based on a Lawyers Weekly article called Autocomplete on steroids. Lawyers reject Microsoft AI chief's claim that AI will replace legal work. And it's quite an interesting article, and it goes on to say that the Microsoft AI chief, Mustafa Suleyman, predicted that within 12 to 18 months, AI could reach human-level performance across most professional tasks, potentially automating work done by lawyers and then also other legal professionals, which I find is quite a bold claim. Legal experts in the article, though, have expressed their opinion to strongly disagree, arguing that AI cannot replace the judgment, ethics, strategy and human understanding required in legal practice. Lawyers acknowledge that AI is already useful for tasks like document review, research and drafting, but it's more so a tool that changes workflows rather than replacing lawyers themselves. The article interestingly also mentions that some lawyers report that their clients are using AI for legal advice, which they then may act on, and therefore when the client comes to see the lawyer, that the issues before the lawyer are actually more complex, which the lawyer then needs to work through. So overall, the consensus of the article is that amongst the legal profession is that AI will reshape the legal industry but not fully automate it, making legal work more complex and focused on human expertise.
Yeah, I think AI has brought a lot to the legal profession, and it's very good at the moment at doing certain things, like you said, document review, trawling through disclosure. But I think particularly in family law as an area, there's such a personal element to what we do. You know, we're dealing with people who aren't always acting rationally. You know, they're in the midst of separation, not seeing things clearly, not just thinking about like the bottom line. So I don't think AI can replace that element.
I completely agree with you, Dina. And that's what's up for this week. For Law in Motion this week, Dina is going to talk to us about the legislative reforms of the 50 years of the family court and also her experience in practice, particularly more recently, and the reforms that she's encountered as well.
Yeah, so a few weeks ago we attended the 50th celebration for the anniversary of the family court, and it got me thinking about, well, what did the landscape of family law look like before the enactment of the Family Law Act in 1975, and how has it evolved over time to get to what it is now? So it's an act that has been tweaked a lot over the past few years. But so prior to having the Family Law Act, in 1961 we had the Matrimonial Causes Act. So what was really interesting about that is we went from a purely state-based family law system to a federalisation of matrimonial causes. So interestingly, that doesn't include de facto causes. But it was quite, I guess, what's the word I'm trying to think of? It was quite revolutionary in that it did federalise divorce matters. Divorce was still fault-based, believe it or not. You could obtain a divorce on grounds such as desertion, cruelty, or adultery.
And knowing that the UK only very recently changed from fault to no fault, for Australia to have made that change so many decades ago, I think it is revolutionary, as you're saying, for Australia. And they were definitely thinking ahead of the time back then, perhaps, as to what should be the system moving into the future.
Yeah, and so interestingly, the court could also deal with parenting matters, but only parenting matters that arose out of a marriage, not a de facto relationship.
Right.
So the Family Law Act was enacted in 1975 and the Family Court came into existence in 1976. The central figure behind it all was Lionel Murphy, and he later went on to become a Justice of the High Court. That's where you might know him from.
Absolutely. A very influential figure for sure.
Yes. And so his initial goal was simple: introduce a no-fault divorce. And so that was grounded in 12 months separation. But in looking at the family law system, he realised he needed to take it a step further and deal with the whole reality of the breakdown of a family and everything that involves. So the Family Law Act, it wasn't just made overnight. There was a very long consultation process, and in that consultation process was when the idea for a specialist family court came about, with specialist training so that court staff could deal with the realities of a family breakdown.
Which is so important, and I know that it has such a positive impact today in terms of the staff and even lawyers getting that specialist training to deal with issues that really only crop up in family law. So to have a specialist court manage those issues as well, it just makes so much sense to us now.
It does, yeah. And so in the first iteration of the Family Law Act, the language that was used was custody and access. So very different to what we know now. And I think anecdotally what we know about outcomes at that point is that we were really ending up with situations where it's sort of like an 80-20 split, you know, time with dad every other weekend.
Yeah.
And so that then led the impetus for the next set of reforms, which came about in 1995. And so really it came about because there was this renewed focus on children's rights and parental roles, and to sort of align the Family Law Act more with the UN Convention on the Rights of the Child. So we did away with the terminology of custody and access, and that was replaced with parental responsibility and residence and the best interests of the child. So getting a little bit closer to what we know now.
And my understanding is those terminology changes were made to make it less contentious in terms of referring to children.
Yes, and more of a focus on the child rather than, the parent's time with the child. Yeah. And so we have the best interest principle. That was a list of 12 different factors ranging from the child's views to whether or not there was family violence and the relationship that the child had with each of the parents. So again, getting close to what we know the law as it is now, but still a fair way to go. So we had that framework then for about 10 years, and then in 2000, by the early 2000s, I would say, there was a growing public debate and advocacy on behalf of groups like the Lone Fathers Association, who was saying, fathers are really marginalised in their children's lives. Despite the 1995 reforms, we're still ending up with the same outcomes, like mum has most of the time with the child. And I guess I use that word, that phrasing, because that's the phrasing that they would use. It's not focused on the child's time with each of the parents. It's focused on the parents' time with the child.
Sure.
And I guess a big part of practice is sort of trying to get parents to refocus on the child.
Which even with changes to terminology, as you're talking about, and it being ingrained in us as lawyers, and we advise our clients of that, it's still something that keeps cropping up, and I think people do forget about sometime that they're not the focus, it is the children.
Well, it's hard. People get so entrenched in the conflict that they can't see beyond it.
Yeah.
Well, anyway, so that then led to the 2006 reforms of the Howard government. And so what we had there was we had the creation of the presumption of equal shared parental responsibility, which then triggered that statutory pathway that we used to know and love, or not love. I remember being a law student and being very confused by that concept. But effectively, as our listeners should know, what happened is that the court was required to consider making an order for equal shared parental responsibility, and then if a positive order had been made, the court had to consider whether or not equal time was appropriate, and if that wasn't appropriate, whether then substantial and significant time was appropriate. What we also had introduced into the legislation was the primary and additional considerations, and so the primary ones being the child maintaining a meaningful relationship with both parents and the need for the protection from harm. Interestingly, at that point in time, there was no prioritisation between those two primary considerations. So I think ultimately what these changes led to was a presumption of equal time, even though that wasn't what the legislation provided for. And I think the outcomes really reflected that. And that's what then led to the next set of changes, which we had in 2012. So we then had an expanded definition of family violence, and that was in section 4AB. And an addition to the primary considerations that the need to protect children from harm should be prioritised over the benefit of a meaningful relationship if those two things conflicted. So again, getting close to what the legislation is now.
Sure.
But I think in that time, since 2012, there's been so much research into family violence and child abuse. And so what came about is that the law's not really grappling with it properly. And so then we had further reforms in 2023. And so that was really to do away with the presumption of equal shared parental responsibility, which was ultimately leading to a preference for equal time arrangements, which I guess as part of my practice, there was such significance, such a push of like, well, why won't equal time work? Yeah. I don't know, was that your experience as well?
Absolutely. And I think the changes definitely have come about over what has happened over the years leading up to it, and then as you're saying, also the movement towards taking into account violence more predominantly, and that showing up in not just physical violence, but then in other ways as well.
And the effects of family violence as well. There's such a greater understanding of it now.
Absolutely. And really making a positive step in that sense to cater for the needs of the society, really, and how we can better provide for arrangements for the children, and even the property reforms as well. I know that there was a lot of consideration into those too.
And so it's really interesting that what we've had is almost a complete undoing of the 2006 amendments, and the whole system has come full circle. You know, we started with this system where there was like a high degree of judicial discretion, and that slowly got constrained when we have things like the legislative pathway. And now we're back to a system where there is high judicial discretion in their judicial making process. And some would say that's a good thing, and some would say that's a bad thing. I'm not going to take a view on that on this podcast. So I guess that also then led me to think, well, how did practice look like when I was a baby lawyer? I don't know about you, but I remember rushing down to court at the end of the day, urgently trying to get documents filed, having to have the original in triplicate, having our 3 copies to get all the documents sealed. If you had to get leave to get a document filed, you had to sit around and wait for it to go up to a registrar.
Yep.
Subpoena hearings, having to do them in person before a registrar. I remember at one of my old firms, and this is sort of just to say how different practice looks now, they would not accept service of an initiating application by email. Can you imagine that?
Which is, today that seems crazy, but there was obviously no faith in email.
Well, I think they might have just been doing it to be a bit difficult, to be honest.
Probably.
Put you to the effort of sending the hard copies.
Yeah. They could, but the fact that they could potentially get away with that's just...
Well, and that's what the rules provided for, so they were within their rights to do that.
Yeah.
And then the other thing is, I remember having boxes and boxes of financial disclosure.
Yes.
Now it's all exchanged via a simple USB.
Absolutely. And albeit it can be painful going through multiple PDFs through electronic form, but it probably is still better. And I know a lot of people complain about it today, but it's probably still better than getting the boxes and boxes of disclosure, as you referred to.
Yes, and having to store them all.
Yeah. Yes, and not to mention all of the paper used as well to print all that disclosure.
Well, and all of this is to say that I think over time everything changes, but nothing changes, right?
Thank you, Dina, so much. I'm sure our listeners found that history very helpful, and then also to hear about your experience of how things have changed more recently. For Case No Corner this week, Dina's going to talk to us about what a judge can do in instances where there's an interim hearing, serious allegations have been made, but the evidence can't necessarily be tested in the interim hearing format if we compare it to a final hearing. Over to you, Dina.
Yeah, so it's a really interesting case. It's called Walsh Walsh. It's a 2025 decision of Campton J sitting in the appellate division. At first instance, the case involved parenting proceedings involving a young child. The dispute that arose was that the mother alleged that the father posed a risk of harm to the child, and specifically there were allegations of sexual assault. The father, of course, contested this, but police did become involved, and there was an ADVO that was put into place. Importantly, the father was only seeking commercially supervised time, and that was a position that the ICL supported. But for her part, the mother sought no contact between the father and the child until those allegations could be properly tested. And so I remember being sort of like a babyish lawyer and having a matter go before the court. It was a legal aid file. It came on very quickly. The matter had already had an interim hearing. And there was some allegations that the other party had acted a bit deviously, but it was importantly not towards the children. and the complainant was overseas, so it was unlikely that they'd be able to be called to give evidence for the final hearing. So my application at that point was to adjourn the final hearing to allow us to get a further grant of legal aid, because at that point we had no funding. And I remember being pushed into running an interim hearing, and I sort of relied on this point. And interestingly, it's from the case of Treloar and Nepean, and so we'll put the case citations in the show notes. But in that case, what the court said was that the court should avoid making findings of fact at an interim hearing because you can't properly test the evidence. And sort of procedural fairness dictates that you have that opportunity to properly ventilate these issues. So here I go into court thinking I have this winning argument. And I did get up on that. But what Camden has said in this case is that if in considering the best interests of the child and whether or not there is a risk of harm towards the child, you can't sort of just ignore these allegations. You sort of do have to engage with the evidence. And it can sometimes require the court to make a finding at that interim stage. So very interesting case. Be interesting to see if that changes the way interim hearings proceed or the way that evidence is dealt with at an interim hearing.
Yeah.
But I thought it was a really interesting.
Absolutely. And when these allegations are being made, as you're saying, the court can't ignore them. And I think in most cases they may err on the side of caution in an interim setting where they can't test the evidence or they don't have the time to necessarily deal with the matter in a way that they would at a final hearing. So it's quite complex when these issues do come up.
And it sort of reflects this, this real focus on the protection of harm, towards the child. And, it's not enough to say, well, we'll wait for the final hearing to deal with these issues. Yeah, go off and have supervised time. The court does have to engage with those issues at the interim stage.
Especially when between the time of an interim hearing and then a final hearing, that could be a matter of years.
Yeah.
So they can't, they have to deal with it to some extent on an interim basis.
Yeah.
Thank you, Dina, for that case note. We've loved being in your ears this week. Please like, subscribe and share this podcast as it helps it get in front of more people. You can also follow us on TikTok and Instagram. And please, if you have a question, you can reach us through those platforms. Otherwise, please email us at familylawpodcast@leap.com.au. Stay tuned for next week's episode. New episode drops every Monday.